The last item of today's list. Finally take this matter exception because two other matters were before vote number one. And those matters were pushed to the next item.
Last matter, item number 8.
Here, one second. Look, MD 404. This petition will be next item.
On the prayer matter on behalf of the parties, let the matter be placed before the next available circuit bench.
No, Blair.
We have disposed of the writ application with the direction upon the Tahsildar Faraghan to consider the and dispose of the written representation filed by you within within 2 months.
Obligation.
And taking into consideration the observations made in this judgment, please go through the judgment, sir.
9/25.
Lord, I am for the
What was the charge? Supplementary presentation form. Yes, sir.
my lord, kindly see the affidavit of service. Paragraph 2.
Affidavit of yes.
Now kindly see the track report. Was not served.
It was at the instruction of the addressee.
My lord, it should be
He was,
refused.
he was intimated and he chose not to receive.
No, my client, you have never gone to the postman, never gone to my client.
Sir, what is the track report saying?
Kindly see the language written. Direct deposit, direct deposit addressee instruction. Why should I will not receive the copy? If it is not served, their conduct will not be seen. If it is not served, if it is really sent to me, why should I refuse? Why should I refuse?
That is on record, sir.
No, it is not refusal.
It is a refusal.
It's not refusal. Talk about this.
And
Served.
It was sent.
Kindly see the language.
order passed in
Order 39 Rule 7, Your Lordship. I don't understand what is
No, it should be given. It was not served.
It was served deliberately. It was refused.
Refused.
Yes, refusal is service.
Where is it mentioned? Refused.
Yes, that is enough. 114, Your Lordship, and Section 27 of General Process Act. It's very clear. It amounts to.
It was not served. It has not giving the copy.
It has been served.
Can one of 2025 is an application. What is your prayer, sir?
My prayer is to recall. I should give an opportunity of hearing.
Seeking seeking recalling of an or judgment and order passed by this court on August 5, 2025. Next paragraph, it has been submitted on behalf of the petitioner that the notice in the revisional application being CO 49 of 2025 was not served upon the respondent.
Yes.
Respondent, and kindly see in the affidavit paragraph 2, they say that it was served.
I have gone through, sir. Please.
Kindly don't take it otherwise. The language mentioned in the affidavit.
I have gone through the language.
It was served.
Sir, I have gone through the language.
Opportunity is to be given. What is the problem? If it is decided on merits,
Will deliberately not receive and then,
it was not deliberate.
yes.
How long will you take, sir?
My lord,
How long will you take? Have you finished?
my lord, it was actually not served.
Have you finished your submission?
If it is any
Have
other,
you finished your
I am
submission?
not yet finished. If it is not served, it is grave and injustice to me. I will say in open court.
Yes.
Have you finished now?
Yes.
Please. Respondent, Mr. B, petitioner in the revision application of an order and judgment and order, obtaining judgment and order being judgment and order dated it was 5th August 5, 2025. Behind the back of the respondents therein. The learned advocate for the applicant in can application 1 of refers to the affidavit of service as well as the track report. Track reports obtained from the website of the postal department. So the next paragraph, the track report shows that the item was under bracket single inverted comma, then direct deposit dash on addressee instructions. Inverted comma closed. Next paragraph. So the according to the advocate for the applicant, notice was never served upon the petition, upon the respondent, and the judgment and order dated August 5, 2025 was passed without providing the respondent an opportunity of being heard. So the next paragraph is the report on the track report shows that the delivered item was deposited directly at the instruction of the addressee. So the next paragraph.
My lord, may I submit one thing,
Yes, sir.
subject to approval? I may be permitted to see the affidavit of service for a minute.
You made the application without going through this.
No, I may be permitted to see that.
Yes, so you can see. But
Well-
you made the application, can application filed by you without going through this.
No, I know that, but I want to see the language.
So by the implement of judgment and order, an application.
Now kindly see this third line, my lord. Third one, return to sender.
Yes, sir. I mean, I have seen it all through.
Return to sender.
I have seen it all through, sir.
It is not, there is no endorsement refusal. Refusal is there, then it is a refusal.
And by the implement judgment and order, an order refusing it was refused originally it was refused by the trial court.
Yes.
Order
Yes.
the order refusing local inspection of the suit premises was allowed and a direction was passed to allow the local inspection of the suit premises by an advocate commissioner for the purpose of effecting certain repairing works. So the next paragraph. So since the notice sought to be served upon the respondent in CO number 49 of 2025 was deposited directly by the postal department at the instructions of the addressee.
My lord, one more thing is that, my lord, the cover received by them, that is to be submitted before this court. Whether they submitted that,
What is this?
whether they submitted that along with the affidavit of service.
That is mentioned in the track report.
Sir, you have been
If we have.
testing the original suit.
I am not an original suit, my lord. Any order being passed, I should be given opportunity of hearing.
It's
That's
what
all.
you are- This client is very smart.
My client is smart, not
Very
smart, that is not relevant.
That it appears to be. And you will start blaming the advocate.
I am not blaming anyone.
Then what, why false affidavit?
Addressee
Was it correct affidavit?
as reported by the postal department. Comma, I find no merit in the application. Accordingly, can one
Supreme Court stay of this order, man.
next paragraph. An order.
This is absolutely injustice to me. Yes,
That I advocate for the petitioner, for the applicant in can one, praise for a stay and a stay
for 2
of the
weeks.
order or the order passed today. Next paragraph. Consider prayer is refused.
Court is doing injustice to me. Yes. Yes, this is absolutely injustice. We no question of order is order in misguiding the court obtain the order.
Closed.
By misguiding the court obtain the order.
It's an allegation about
Yes.
us directly. I am misguiding. That means what? What is this?
What is party to that?
Lordship, I along Mr. Sumit Karmakar is appearing for the state Lordship. Very innocuous prayer, Lordship. They want that their case should be heard out within a period of 1 year and it can be disposed of within 1 year by the trial court. Out of 22 witnesses,
Here, out of 20
10 witnesses has already been examined.
examined.
Lordship.
And what do you want?
My lord, I pray to that the trial will be through in the within a time frame, because the charge was paid in the 20.
Sir, this is deprecated by Supreme Court.
My lord, I am not taking the specific time frame may be framed, but spirit disposal direction may be given to do not
Yes.
grant unnecessary adjustment to the party as well. That direction will be given, preferably within a span of 1 year or 2 years.
Within a period of 2 years, Lordship.
How many witnesses are yet to be examined?
Out of 22, only 9 have been examined till now. The charge.
As per my information, Lordship, 10 witness has been examined.
Out of
12 out of 22, 12 witness, 10 witness has been examined, 12 witness is left. And it is not that regularly the witness are coming.
In the 8 years, my lord, only 9 have been examined.
the instant revisional
If
application.
we will call for the record, it will show each and
Fine.
everything.
Okay, so I'm seeking a direction upon the Learner Trial Court to direction upon the prosecution. Upon the prosecution to examine the witnesses on a day-to-day basis and to conclude the trial at an early date. With a direction upon Learner Trial Court not to grant unnecessary adjournments. Next paragraph, Learned advocate for the petitioner submits that the trial in FIR number 67 of 2014 dated March 2, 2014. Uh, is underway. So out of 22 prosecution witnesses, 9 have been examined. Examined. That should be issued in against the petitioner. Whether should be issued upon the prosecution to examine the witnesses on a day-to-day basis and to conclude the trial at an early date. So be on the other hand, and an advocate for the you are for the state.
Lordship, I along with Mr. Karmakar.
For the state submits that as per his instructions, 10 out of 22 witnesses have been examined. Now, next date is fixed on? The trial is
25th of this month.
trial is fixed for recording evidence of the prosecution witnesses on August 25, 2025. Next paragraph. In the aforesaid circumstances, the instant revisional application being CRR 46 of 2025 is disposed of with a request to the learned trial court. Trial court is
Usually makes it first class.
that is highly going the Court of Learned Judicial Magistrate at Port Blair.
Put that.
Port Blair to dispose of the trial and to dispose of the case concerning concerning FIR number 67 of 2024 as early as possible without granting unnecessary adjournments to either of the parties. Preferably within a period of how many witnesses are yet to be examined? 10, 12.
12 witnesses.
Within a period of 1 year.
Lord, 1 year.
Within a period of 1 year.
In case of GR case number in the record. GR case number 230 of 2017.
Have you given that in your petition?
Well, it was there in the first page.
Huh?
It was
First
there in
page of the petition.
First page of the petition, GR case number 620, GR case number,
And GR number 230 of 27.
both the cases.
It was single case only. Earlier it was this GR case.
Okay.
Then it has been transferred.
FIR number, GR case number
230 of this.
230 of 230 of 2017.
Obliged, Lord.
Okay.
Dispose of.
You have 47
Lordship,
I have been seeking this.
I am appearing on behalf of respondent number 3, Lordship. Here I am challenging the maintainability of this application because this is a association, Lordship. No resolution has been taken to file this present
And
proceeding.
this is not a public interest litigation.
Resolution has to be taken because this is the association. This is the association. I have the decision, but right now I do not have. Let it be in the next circuit bench. It is required.
The disposal of this particular case.
Lordship, then also they have to come
Let him
with.
complete, then I will make my submission. Let him complete.
Particular case of what?
Your Worship, I kindly come to page number 14.
What?
Let's see.
That is for opening of the bank account.
Page number 1 4.
Yes.
Now, this is the conditional order which has been passed by the sub-divisional of magistrate. Got it, yes?
133.
Yes. Case number 159 of 2020. I am seeking disposal of this case.
Take necessary.
I am challenging the maintainability of the application. If application is not at all maintainable,
The finding.
the person who has affirmed,
Let him complete, then I will make a submission.
I am challenging the
He-
maintainability,
he-
so I can.
He doesn't want to complete. He seeks for next circuit.
No, Lordship, because I will bring the judgment. Judgment is there.
I was the.
In opposed prayer, but he has to come with clean hand.
The proceedings.
Hmm.
I was
Right.
the party to the case. That party has come before this honorable court.
Next circuit. On the behalf of payment on behalf of the advocate for respondent. List the matter in the before the next available circuit.
Obliged.
I'm for the response.
That means it's illegal. Prior to selling of the property, non-agricultural land, one has to take the permission. As per that, mother.
Permission for what?
For selling of the property.
Okay.
Here, mother, I have applied through online. And it was rejected. Kindly see my rejection, 35.
Page?
It's 35, mother. Next step, please do. I have applied it. And it was rejected. On the,
NOC of co-tenant in the shape of affidavit
one,
to the executive magistrate is required for prohibiting sale permission since the field in online application is not editable. Any such application needs to be rejected. Yeah.
that was not given.
And
And this order.
they are saying
This order passed by, has to be passed by the deputy commissioner as per the land revenue and land reforms regulation. 159 says the permission has to be, 159 of the regulation. And 116A is the condition, what and all condition has to fulfill one person so that I can get the sale permission. That is there. In the condition, this condition is not there. Moreover, you know, this honorable court, Justice Jyotirmay Bhattacharya and Justice Somen sir, they critically stated that the one person, if they are the co-tenant, they can sell their share. That is their number. This is the two judgments, sir, of 2008 and latest judgment.
they are not saying they will not give. They are
Rejected, my lord. My lord, they are saying, I have to take, no objection 24 tenant. That is not required. These judgments are there. For selling of the property, I can sell my share. If I am a.
this will require an affidavit.
My lord, this will require an affidavit since, my lord, they have,
Because 158
my lord, they have applied for the sale permission entire land of 98.
Yes.
And whereas he is having only, his share is 22 square meters. But at the time of applying for the sale
If it-
permission, my lord,
Keep
he
it with
has
you.
applied the entire land. He
He
cannot do that.
All of you?
Only for this share he can apply for. So the application itself was defective. my lord.
Petitioner and respondent are represented, Stoppel and advocate for the petition, for the respondent seeks to use an affidavit. So here, let affidavit in opposition be filed within 2 weeks. Within
3 weeks, my lord.
2 weeks.
2 weeks, my lord. 2 weeks.
2 weeks. Reply if any within a week thereafter, within 3 days thereafter. Okay. Please the matter before the next available circuit.
Right.
Okay.
Very for the petitioner adoption. This writ petition is related to the value added tax fees. The similar order has been passed by this honorable court as well as court number 1. Increasing the amount.
Who is for the other side?
Sir, I'm appearing to answer.
Sir, I have, do you have any objection to this order?
Earlier also, the Lord has passed the order.
No, all good. Similar order may be passed.
It's like.
Anyway, for the petition, very innocuous prayer. My petition for demarcation is pending.
I appear for respondent number 1 and 2. There are other private respondents.
You are appearing for whom? 1 and 2, no?
1 and 2.
You are appearing for, huh?
Serve them. My prayer
Others,
is,
others?
he is appearing, will, so you are appearing for admission.
No, no,
Yeah.
there are other 3, 4.
I have served it, your lordship. That
Where is the affidavit?
acknowledgement is also there.
Where is the affidavit?
Service digit? Okay.
No. Back to you.
Already fine, maybe it is lying in the registry. It was served through the courier, they have received it, and that endorsement of receipt is also there. What I pray, your lordship, my prayer is, my application, that is lying at page. Start from page 32 to 34. The respondent authorities may be directed to dispose of this representation within a time frame. In the meantime, I saw.
34 is the last page. And you are only that to pass necessary or direct opposite party to stop the ongoing construction and direct Tehsildar to produce relevant documents,
Assembly of survey number 447.
including assembly of survey number. And who are these persons?
They are the private respondents.
Respondents,
Private respondents.
they are
They
interested.
are neighbors. There is a boundary dispute here also. What I pray,
But
let parties may be given opportunity to participate.
my submission is that this writ application is not maintainable. Because currently see page number 28, the survey number 428 may be seen, your lordship. Second para, as per record, the survey number 448/1, area is 4,100 square meter. Stands recorded jointly in favor of these 22 persons. And as such, this survey number belongs to 22%. Petitioner, one single person cannot file a. Yes.
47.
No, 447 is not the recorded land of the petitioner.
Is not.
There are many.
It is the recorded land of the private parties.
Why he is very apprehensive, I fail to understand.
Kindly-
I'm seeking a direction from this honorable court. to give
Only as per
notice to
recorded as.
respective parties. I'm asking, give notice to respective parties. It is not that behind the back of anyone, I want the demarcation to be done.
No, kindly see 448. In the page number 32, they are telling stop the construction in survey number 48/1. Now my landed friend is telling 447. So why you make a false submission then? When I say 448/1 is belonging to 22%, you say that no, I am not claiming 448, 447 she is telling.
447 belongs to him. There is a boundary dispute. Let that be resolved. Directing upon the deputy commissioner or to Tehsildar to resolve it.
It's not belong to me, it is belong to the private respondent.
The parties. That is permissible under law. I'll just refer section 8.
Section 8.
Section 101 and 97, I believe.
But when there are 22% jointly as a shareholder, all the persons are having share.
Hand in glove with the private respondent. that is
Self
the case of-
your prayer is with regard to 447
Boundary dispute between 448 and 447.
and you belong, your land is
448/1. It is 448 is
First,
22 persons,
Every now and then.
not her alone. It is 22 persons are there, your lordship.
He's making.
No, my submission. No, my submission is on the maintainability point.
maintainability.
Because the 448 is recorded in the name of 22 persons. So all the 22 persons having share in the survey number of 448.
He's stopping you.
So how can she alone file a petition?
And there is no demarc,
It means my interest will not be protected.
is it demarcated?
It cannot be demarcated. Her share cannot be demarcated unless it is divided. 22 persons are there in the survey number 448.
32 persons are there.
Yes.
If he is having a problem, our client is having a problem, the owner cannot seek any relief unless and until all 32.
She has made party to all the persons. All the 32 persons have been married as a party, your lordship. They all are having a share in this subject line.
How many? How many?
22, page number 30, 28,
And how many respondents have? Only 5.
only 3. Private respondents are only 3. Kindly see page number 28.
I think finish first, he started, before I could make any submission, my land brother.
No, ma'am, my lord has asked me, I have submitted my intelligent point. I can.
Madam. Madam,
Yes,
please.
Lordship, my submission is very innocuous. There is a boundary dispute. Let that be adjudicated by the revenue authorities by serving appropriate notice to the other side. That is what is my prayer. I'm not asking any to stall the construction, not to call anyone. Very innocuous prayer.
If we are to act in accordance with law.
The prayer may be seen 34 to stall the construction. Stall the construction.
Say that.
Your prayer is that.
Where is your this application dated 3rd of March?
Yes, sir.
Page 32.
Yes,
Yes, page 32.
34 is the prayer. This is not the boundary issue. They are telling that to stop the construction of the private respondent.
Refuse it saying that there is no boundary dispute.
No.
They are not saying that. They are just saying that all the
My lord.
joint owners. So please to pass necessary or directing opposite party to stop ongoing construction.
If that be so, your lordship, while he has entertained one petition, I'll just show your lordship. One application was filed by the,
Please to pass necessary order directing opposite party to stop ongoing construction.
that I'm ready to forego. The only thing is I have to.
That is the only prayer.
You cannot forego that application is with the authorities.
Yes, they will adjudicate, your lordship, they will adjudicate. I'm only seeking an adjudication.
এটাতে
छोटा से prayer के लिए disposal के लिए दिखना और
Madam, where is the this is through courier.
कोई भी नहीं पूछ रहा है. Lordship, may kindly come to page 20. When the private respondent has made an application that was merely entertained by the respondent authorities, they said no. They were ready to adjudicate all such things.
Application, the application of the area for that.
It is in regard to their land. It is in regard to their land.
Whatever, this has been received by 3, 4, 5. So I don't know.
Mother was received. Mother was there at home. The Telugu signature is there.
All 3 by 1.
For all the 3. They are
All
staying in one house. I am not seeking any direction upon them also.
जो हमको लगा
नाम नहीं कराने के लिए बोल दो.
The instant writ petition, and this is a writ petition, has been filed by the petitioner seeking a direction upon the respondent authorities to hear and to dispose of the application of the application filed by the writ petitioner on March 3, 2025. So a further prayer has been made by the writ petitioner that the authorities may be restrained. Authorities may issue necessary directions restraining respondent number 3, 4, and 5 from carrying out any type of construction till the proper demarcation of the land in question. Stop the an application was filed by the petitioner before the authorities with similar prayers. Stop the, however, in course of hearing, learned advocate for the petitioner submits that she doesn't want to press her prayer for a restraint upon the construction. Stop there. She seeks a direction upon the authorities to consider and dispose of the application filed by the petitioner on March 3, 2025. Upon hearing all the parties. Upon hearing all the parties, all the interested parties, stop the learned advocate for respondent number 1 and 2 is present. Stop the affidavit of service in respect of 3, 4, and 5 is taken on record. Stop the none appears on behalf of respondent number 3, 4, and 5 in spite of service. Stop the next paragraph in the facts and circumstances of the case, comma, let the writ petition be disposed of with a direction upon respondent number 1 and 2 to hear and dispose of the application filed by the writ petitioner on March 3, 2025 in accordance with law. In accordance with law, the respondent authorities shall be at liberty to hear of such other parties and consult such other documents as the authorities may deem fit and proper in the facts and circumstances of the case. Stop here. It is expected that the respondent authorities shall dispose of the application dated March 3, 2025 within 2 months from date.
Let it be 2 months.
So there are so many interested parties and they have to be served.
No, no.
6 weeks.
2 months.
People understand. Within 2 months from date, upon due service of notice upon all the interested parties.
Oblige, my lord.
That which I was asking. I think. Don't want to give.
Petition is disposed of accordingly. আছে তো